I would like to take a moment to talk about United States of America v. Christina Kelso. This is a federal case where the defense is pro se and rather interesting. We're going to start with a United States opposition because I think it really sets the stage, and then we are going to take a look at the brand new document in response to the U.S.'s opposition. The United States of America, by and through its attorney, the United States Attorney for the District of Columbia, respectfully submits its opposition to defendant Christina Kelso's motion to dismiss. In the motion, the defendant offers nothing beyond speculation, untethered from relevant facts or legal analysis to support her argument that the case should be dismissed because she claims the players at all levels of the justice system, including the court and prosecutors, are impersonators of officers in violation of the defendant's owed due process. The defendant does not offer a substantive argument. Instead, she merely refuses to acknowledge the authority of the court. See, then I have a list here of the administrative Article 1, bank teller, not a real judge, lacks the necessary original jurisdiction, Article 3, to make any judgments against Christina in a criminal cause due to this fraud on the court. Defendant's entire argument boils down to this. In certain instances, the oaths of judges, prosecutors, and other public officials capitalizes the language, "so help me God." The defendant interprets the capitalization of these four words as contrary to the statutory text and so thoroughly defective as to divest this court of jurisdiction. But the defendant offers no legal basis to believe that the capitalization here is of any legal significance, and the government is aware of none. And here we have Merrill v. United States. The court still fails to understand the unusual theory of Mr. Merrill concerning the typeface used to print "so help me God" on the certificate memorializing the oath of office. So this is not the first time this has been tried. Here we have another one. Collecting cases rejecting similar arguments surrounding the capitalization or not of a litigant's name. As other courts have recognized, the true purpose of pleadings like the defendants is not to raise or resolve genuine legal disputes, but to attempt to delay judicial proceedings. So they are arguing this is just a delay attempt. Noting that defendants who do not recognize the authority of courts raise frivolous arguments in an effort to clog the wheels of justice and delay proceedings so justice won't ultimately be done, they do so by raising numerous, often frivolous arguments, many alleging the courts or the Constitution lack any authority whatsoever. The defendant's motion is a prime example of such frivolous filings. The court may dispense with it promptly. In absence of any substantive argument from the defendant to justify her motion, the United States respectfully requests the defendant's motion to dismiss be denied. And this is respectfully submitted by Matthew Graves, United States Attorney. So, of course, it's not going to end there. They have a response with, we'll just let it speak for itself. Comes now Catherine Christina of the family Kelso, Christina, and redeemed. Demand is made for redemption of central banking currency in lawful money in all transactions pursuant to Title 12 U.S.C. 411 as amended from 16 of the 1913 Federal Reserve Act. The Department of Justice response is refused for cause, as Rudolph Contreras' statement on the transcript of the status conference on 11/22/2024 that Christina had not cited law behind her assertions, that Rudolph Contreras was not I'm going to say that wrong every time, Contreras is not a judicial officer because his oath is deviant from the form prescribed by law. Here is an example of law. Exemption from taxation. So we have you can read that if you would like and pause. I'm not going to read that. And here we have just historical revisions, and we have more listed here, and we continue. The italics Times New Roman in 13 size is emphasized because in this law's history, any little change that Congress might make is recorded and made very clear. Even why the change? This is common law, the United States Code. Instead of showing where "so help me God" on any federal judge oath has been changed to "so help me God" by Congress, the prosecutors cites precarious case law from the Court of Federal Claims, inciting from a known ideologue, Victor John Wolsky. A passage from the Senate confirmation hearings is highlighted below. Wolsky, a self-admitted ideologue, has jumped on the chance to legislate from his bench the legality of judicial officers changing the form of their oaths of office. So she's not liking the judge that made the decision here. It would appear that the prosecutor is simply saying that it is okay to alter, amend, or otherwise change an oath of office, and Rudolph Contreras, I'm going to say that wrong every time, dismissive attitude towards Christina Kelso's case carefully crafted 119-page refusal for cause. There's a lot more if you want to hear about this case. You can look it up, as you can see here. It becomes convincing that Wolsky, the Department of Justice, DOJ, and Contreras are in collusion to gaslight defendant Kelso. So she is accusing them of gaslighting her into thinking that the oath of office for Contreras is okay even though it has been altered, and that by ideologue Victor John Wolsky becoming confused about his own oath in 2015, he is allowed to create law sterdices. I'm probably mispronouncing that. And right here, and we have a term from an old movie, majority in collusion, briefly dimming the lights, behaving like nothing is wrong, while the minority victim is left doubting they have a proper grasp on reality. So it's gaslighting if you say that she's wrong, I guess. That's what she says they're doing. Then the clerk of court removed or deleted the case from Pacer on and around 12/7, then thought better of it and posted it back on Pacer. So she's claiming that the case cited was actually removed from Pacer. I don't know. I don't know if the website was having issues or what, but that's what the claim is here. That's what the image shows. Object not found. It shows the case, so the case is found. It looks like an object from the case was missing, maybe, or not working. Between the prosecution and Contreras' criminal impersonation of a federal judge, we have collusion and conspiracy, and compounded by all federal judges, in quotes, being actually non-judicial officers, criminal syndicalism, especially when one shines a truthful light upon the national debt and Federal Reserve System being behind such a subtle ploy. This response to the response will focus on Contreras' point that Christina has not cited any law. Untrue, the law is cited at the top of Contreras' oath of office. And here is the oath of office, and we have right here Title 12, Section 453, and Title 5, Section 3331, United States Code. And we have the oath of office with written on it, refusal for cause, so help me God, no. All right. The combined federal oath in itself is a deviation in form, mixing civil oath with judicial oath, just like we see with Rudolph Contreras as above. This invention is attributed to justice of the U.S. Supreme Court. So we're going against the Supreme Court now? And the form of oath is clearly matter of law. The SCOTUS is a judicial body that has no business creating or amending a law. The Congress is the legislative branch of the U.S. government, and Congress has never entertained the amendment to the oaths of the combined oath. The amendment of the oaths to the combined oath. Regardless of how you might trace the legislation history of the oath office, there will never be any authoritative explanation why Contreras has changed the sentence "so help me God" to "so help me God." Rather than gaslighting Christina that she quibbles about gnats, he might simply explain why his oath is different in form than that prescribed by law. And here we have congressional records. And as you can see, "so help me God" is capitalized differently. Justices Neil McGill Gorsuch and Brett Michael Kavanaugh should not be considered extremist minority purists for simply conforming to law. Justice Kavanaugh has said publicly that justice Rehnquist is an all-time mentor figure, but the law in action shows the only oath of office available for DOJ for John Glover Roberts is from this circuit Justice days and does not conform to law. The Roberts oath is, however, signed by Justice Rehnquist, and presuming people read these oaths before signing indicates that Article 3 Justice Rehnquist can sign for whatever administrative law office central bank teller Roberts is officially, but looking at the judicial oaths of Justice Kavanaugh and Gorsuch, it does not work with authority the other way around. And here we have the Justice Roberts oath, refusal for cause no. The big point Catherine Christina Kelso is making before the court is a matter of common law maxim to never leave the fox in charge of guarding the henhouse. Whatever the reasoning and history leading up to the deviation, the mission behind the motion to dismiss is to expose that Rudolph is not just a judicial officer, but that he pretends to be a judicial officer, and that is fraud. It is absurd to think this acute approach to exposing this lack of bonding might lead to punishment or penalty like revocation of her bond, or that Christina might be considered mentally unfit for trial and railroaded into a psychological evaluation for simply wanting a coherent explanation why Contreras, who does D-E-I-G-N-S. I'm honestly not sure I've ever seen that as a word. Not saying it isn't, not saying I probably don't know it. So we're going to continue on. To judge her is deviant in form. It is absurd to think that once Christina became aware of the deviant oath that she might ever be arraigned without any coherent explanation why Contreras has signed to "So help me God." Christina has made it sparkling clear that she feels the deviant oath and fraud leave the court devoid of jurisdiction and authority. Christina is fully aware that she has dodged the bullet by attempting to abate this nuisance and not being penalized. Christina fully intends to honor any obligations to appear and defend at trial as though things are up front and kosher. So this is actually kind of important because the person, from my understanding, that she's getting these ideas from and who is helping her did not show up to their own sentencing and had a warrant for their arrest. It would indeed be cruel and petty to revoke Christina's bonding and bind her in jail until trial in September. Simply noticing the fatal flaw in Contreras' oath is not a sign of mental illness or incompetency. And here we have, what is this? Senate floor, July 9th, 2003. Nomination of Victor Wolski. And we scroll down through. I urge Mr. Wolski's nomination be defeated. Okay. And here we have William Hubbs. Rehnquist has signed a properly formed judicial oath. So here's one that is, as you can see, different. And here we have John Glover Roberts has signed a deviant oath. So help me God. His USSC appointment has no oath according to the Justice Department of Justice. And here we have another one. It's a little different. So help me God. So help me God. So help me God. So help me God. Final note. There may be a good reason to avoid creating embarrassing case law at this moment in American history. And here we have statement from the press secretary regarding executive grant of clemency for General Michael T. Flynn. So I'm assuming they're putting the note here like basically you don't want to cause case law by not doing what I asked. That's how I take it. And then they use this Michael Flynn clemency. And then we just at the end have a final refusal for cause. So, if you're interested in this case, there's the case number at the top. There's a lot to it. As you can see, there's a 119-page document. There's also the guy she's doing stuff with. She has his photo, I believe, at the very end of the 119-page document, along with his name. And if you look up his case, he has a bunch of documents that are very similar there. And the result for him was guilty, sentenced, and served his time. So they're hoping for, I guess, a different outcome this time. I don't know. Thought I'd share. Thought someone might find it interesting.